In October 2024, the government unveiled its Employment Rights Bill, which is currently making its way through Parliament to become law. This bill introduces major reforms to workers' rights. This podcast is part of a series of podcasts which will be discussing some of the main provisions of the bill. We previously discussed the government's proposals with regard to unfair dismissal, family rights, collective redundancies, flexible working, and sick pay. And in this podcast, we'll be discussing changes to fire and rehire practices, harassment, zero-hour contracts, and tribunal limitation periods. My name is Louise Keenan. I am an associate in the employment team at Clarkslegal, and I'm joined by Lucy White, who is a senior solicitor at Clarkslegal. I will start by saying that as this bill is making its way through Parliament still, it is subject to amendment, so some provisions may change by the time it's enacted, and we have seen lately a few suggested amendments being proposed. So let's start with fire and rehire practices.
Thanks, Lou. So, yes, this refers to the practice of dismissing employees and offering them re-engagement on new terms, usually when they have refused to agree contract changes driven by the business. Employers have to have a sound reason for wanting the change, but this does not currently need to be crucial to the survival of the business. This is changing under the Employment Rights Bill. However, there has been a recent proposed amendment to the bill, so we'll talk through both the current version and the proposed amended version.
Yeah, they don't make it easy for us, do they?
No, sadly not. So the current version is seeking to ban fire and rehire practice in almost all cases, except where the business is at risk of complete financial collapse. What it's suggesting is that any dismissal for failing to agree a contract change will be automatically unfair unless the employer can show that the reason for the change was to eliminate, prevent, significantly reduce, or significantly mitigate the effects of any financial difficulties that were affecting or were likely to affect the employer's ability to carry on the business as a going concern, or otherwise to carry on the activities constituting the business. And in all the circumstances, the employer could not reasonably have avoided needing to make the change. However, the proposed amended version of the bill is watering this down slightly.
Yeah, it's suggesting, isn't it, that this restriction on using fire and rehire practices will only apply to what it calls restricted variations. So these restricted variations are variations around pay, which is any sum payable in connection with employment, not just salary, though regulations may carve out some things like benefits in kind and expenses. Variations relating to the amount of work done where this impacts pay, variations to pensions, variations in the number of hours to be worked, reductions to time off that employees are entitled to, variations in timing and duration of shifts which meet conditions that need to be specified in regulations, and other variations which are to be laid down in regulations later. It also applies to any attempt to insert a clause into contracts enabling an employer to make any of these changes I've just mentioned unilaterally. So, for those I've just mentioned, the new rules would apply. But for other changes, like changes to territory, job title, duties, etc., they would be covered by the existing rules. So you could still use fire and rehire practices for those without having to show that you were in this significant financial difficulty. But the Employment Rights Bill does set out factors that have to be considered in assessing if a dismissal is fair in these circumstances, which include the reason for the variation, the consultation carried out, if there's a recognised union, the consultation carried out with that union, and if there's no recognised union, the consultation carried out with anyone else representing the interests of the employee who had authority to receive all the information, etc., and any inducement offered in return for agreeing to the variation.
Yes, that's right. Now, this practice of fire and rehire, whilst legally permissible currently, has received a lot of negative attention in recent years. So the idea behind the new bill is clearly to avoid undue pressure being put on employees to change their terms, save for where the business is in these severe financial difficulties. But the new proposed amendment recognises that there are some changes that may need to be made, which presumably it considers less serious on the employee, which can be made under the usual rules, which is going to be seen as a positive step for employers.
Yeah, and it's worth saying, isn't it, that in practice, a lot of employers don't like to use fire and rehire practices anyway, because it's quite drastic and it carries a lot of risk. So, we have also seen the introduction of stricter rules being applied through the Code of Practice on dismissal and re engagement, which can be taken into account by a tribunal when assessing compensation for claims like unfair dismissal if it's not followed. But the bill clearly goes further than this.
Yes, and where the new, more restrictive duty applies, it's going to be interesting to see which companies are going to try and still use the fire and rehire practice, and how the new test will be interpreted by tribunals, and what evidence they'll want to see to demonstrate the financial position of the employer.
Yeah, exactly. Tribunals are not financial experts. So, our party is going to be expected to call a financial expert to give evidence on the state of the company. I mean, that's certainly going to add to the time and cost of the tribunal process.
Yeah, exactly. And we know that tribunals are already stretched and clearly will be more so following the changes coming in.
Yeah, so employers who are thinking about contract changes now may want to consider whether they need to start that process soon if dismissal and re engagement is something that they were considering, as clearly that option is going to disappear in many respects when the new law comes into effect.
So let's move on to harassment. If we start by considering sexual harassment, currently, employers are required to take reasonable steps to prevent sexual harassment of their employees during the course of their employment. Employment tribunals have the power to increase compensation for sexual harassment by up to 25% if there is a breach of this duty, and the Equality and Human Rights Commission has the ability to take enforcement action. The Employment Rights Bill changes this duty to one to take all reasonable steps. So it's currently reasonable steps. In the future, it will be all reasonable steps.
Yeah, it seems like a small change on the face of it, but it does actually have an impact, doesn't it?
It does, yes. It means that an employer is likely to have to demonstrate that there were no further steps that they could reasonably have been expected to take. This makes the duty harder for employers to comply with and opens employers up to challenges if the employees can show just one further step that the employer didn't think of but should have taken. Regulations are likely to set out in more detail what reasonable steps may be, and could include things like carrying out risk assessments, publishing plans and policies, having clear reporting and complaints handling procedures, etc.
Yeah, a lot of employers carried out risk assessments in line with the current duty to take reasonable steps when it came in. And so these just need to be reconsidered to see if further steps can be identified. And anyone who hasn't yet conducted a risk assessment would be wise to get that started ASAP.
Yes, now looking at third party harassment, which is another area addressed by the bill.
Yeah, prior to 2013, the law held the employer responsible for harassment from third parties, where the harassment occurred in the course of the employee's employment. The employer failed to take such steps as were reasonably practicable to prevent the harassment, and the employer knew the harassment had occurred on at least two previous occasions. Now, this law was repealed in 2013. However, the Employment Rights Bill seeks to introduce a form of third party harassment again. Now, employers will, under the bill, be liable for third party harassment where the employee is harassed in the course of their employment and the employer fails to take all reasonable steps to prevent this. The duty will therefore be more onerous on employers than the previous law, especially those whose employees come into contact regularly with third parties, such as those in client facing roles.
Yes, and the Employment Rights Bill also specifically confirms that reporting that sexual harassment has occurred, is occurring, or is likely to occur will be a protected disclosure for whistleblowing purposes. Now, arguably, sexual harassment complaints would already be a protected disclosure anyway, but specifically including them removes any argument to the contrary.
Yeah, and the Employment Rights Bill also calls for regulations requiring large employers with 250 employees or more to create and publish yearly equality action plans to address matters like the gender pay gap and to support employees through the menopause.
Yes, and further regulations may be made under gender pay gap provisions, as well as to require private and voluntary sector employers with 250 or more employees in Great Britain to publish information about the service providers they contract with for outsourced services.
So there's a lot of changes there. And like we said, it will be important for employers to complete risk assessments so they can understand and mitigate risks. Organisations will also need to consider potential wider reporting obligations and whether there are any steps they can take now to place the company in a better position.
So let's turn now to 0 hour contracts. We know that these have been viewed negatively for quite some time, as they typically apply to low income employees and offer little job security and limited rights. Up until a decade ago, these could contain exclusivity clauses as well, which restricted 0 hour workers from undertaking other work, but this was banned in 2015. Now, the Employment Rights Bill, there are a number of changes to try and stamp out exploitative 0 hour contracts. These also apply to those on so called low hour contracts and also to agency workers. First, there will be a duty on employers to offer a guaranteed hours contract to qualifying 0 hour workers, low hour workers, and agency workers. This will reflect the hours that they regularly work over a reference period, which is to be defined, but the government had suggested it may be 12 weeks. There's a current proposed amendment to the bill to make this 26 weeks, but it's not backed by the government, so it seems unlikely that it will be picked up. The employer will have to make an offer for this contract to the relevant worker at the end of each reference period. So employers will have to have a way of tracking this and making repeat offers. Regulations will be required to set out, for example, who qualifies as a low hours worker here. So we don't have a complete picture yet on who this will impact. Though, again, there is a proposed amendment to the bill to suggest that those working 8 hours or less a week, but it's not an amendment supported by the government, so again, may not be adopted.
Do you think there will be an option to opt out, for example, for 0 hour workers who like their arrangement and don't want to keep being offered the guaranteed hours model?
There's reference to being able to contract out by collective agreement, but not on an individual basis. There have been calls for this process to switch from the employer having to offer the contracts to the worker having the right to request it, which would deal with the issue you mentioned. But this proposed amendment has been put forward but doesn't have the government's backing, so it seems unlikely that it will be taken forward. There's also interesting issues arising, like how employers will deal with seasonal workers.
Yeah, because they're hired for busy periods, aren't they? So an employer's not going to want to offer a guaranteed contract to a seasonal worker that would result in them having to keep the worker on past that busy period.
That's right. And under the new provisions, any guaranteed hours offer should not be made on a fixed term basis unless it is reasonable. And then there's provisions setting out when it might be reasonable, which may help with things like temporary demand, but information is still needed in regulations and it's not clear cut. Organisations are going to have to really think about engagement models and risks. And there are anti avoidance measures in the legislation to avoid employers purposefully structuring arrangements to try and circumvent the new rights. So it's going to be a very complicated process for employers to assess their risks now and consider alternative working arrangements where the new system poses issues for them.
Yeah. There will also be a duty on employers to provide reasonable notice of shifts, including the date, the start and end times and hours to be worked to certain workers. And that includes 0 hour workers and those on low hour contracts, but also others such as those with no contractually guaranteed shifts and agency workers. Once again, some of the details to be provided in regulations and things like what is reasonable notice are to be consulted on. These workers will also be entitled to compensation if their shift is cancelled, moved, or curtailed at short notice. And again, details are to be set out in regulations, including the amount of compensation, but it won't be more than the amount they would have got had they worked the shift. For agency workers, it will be the agency that will be responsible for the payments, even where the end hirer has changed the shift. And so end hirers may find agencies start negotiating this as part of their commercial arrangements.
Being penalised for exercising their rights. For example, it will be automatically unfair to dismiss workers in certain circumstances relating to these rights, including dismissals because someone has asserted their rights or accepted or rejected a guaranteed hours contract.
All in all, the new provisions don't go so far as to ban the use of these types of contracts, but they're clearly complicated and put more obligations on employers. So we may find that in practice, they reduce the chance of employers wanting to use them.
Yes, and at this stage, as we've said, employers should be looking at their workforces and identifying how many of these types of workers they engage. Those operating shifts will need to review their current processes to see how efficient these are and whether they could be improved to help deal with changes. Much of the detail for these changes will be coming in regulations, and so it's difficult to fully prepare or understand the risks here. But for large organisations, identifying these workers in their business may take time, so it's worth starting it now and giving thought to whether there are alternative ways to engage these workers.
A final point to mention is in relation to tribunal time limits. So employers currently have 3 months to pursue most claims in the employment tribunal. However, the Employment Rights Bill is proposing to increase the time limit to bring all types of claims in the employment tribunals from 3 to 6 months. However, there appears to be an exception to this in regards to breach of contract claims, which remain outstanding on termination, which would still have their current time limit of 3 months from the termination date. And it's not clear yet if that was intentional or accidental. This will clearly have a significant impact on employers. They may well face more claims and will need to consider what they need to do now to try and preserve evidence and witness accounts of events, given the longer period that may lapse between the events and the claims.
Yes, absolutely. So that brings us to the end of this podcast. As the bill progresses, we will certainly have more updates for you and hopefully more clarity on some of the points we've discussed. If you'd like any further advice on what we've discussed or guidance on getting your business ready for the bill, please do reach out to our employment team. Thank you for listening.